We start the agenda. There was an item from last month where we had Rosedon Property had requested a continuance, but nobody was here to speak for them.
Good evening. Sorry for that miscommunication not being here last month. I'm William Brennan, here for the Rosedon Holding Company Limited Partnership. It's actually application number 2782. You may recall it was for a specialty storage facility at 147 Pennsylvania Avenue. Zoning relief was indeed granted October 30th of 2008. There was, we call it the grace period, I guess, for the first extension. On October 15th of 09, there was an extension granted by the board to the applicant. And we're here again requesting another extension. It's actually our second face-to-face meeting to do this. I don't want to just say the economy is the issue. I have brought Vice President of Development Brian Shea, who's with the company with me, and I would like him to explain to you in greater detail the particulars of why we are where we are, in addition to just saying, you know, the economy is bad, which it is. So, Brian, with that, would you be kind enough to tell the board?
Do we need to swear him in if we're taking some testimony?
Yeah, I
here?
think we should swear him in.
Okay.
Also, it's my understanding, Madam Chairman, that we had a 6-month extension. Sorry. It's my understanding, Madam Chairman, that we were asked for a 6-month extension last month, of which we gave 1 month, and the other 5 months are before the board right now as to whether to go forward.
Yes.
So I think our posture is it's no more than 5 months.
I
Another
agree.
five.
It's a
Yes.
request for 5
Okay.
months. That's right.
All right, may we swear in your witness,
Absolutely.
please? Do you have a handheld mic there, or can you point that one over towards you? Okay. And your name, please?
My name is Brian Shea.
S-H-E-A?
Yes, ma'am.
Okay. And were you going to swear them in?
Would you raise your right hand, please? Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Brian, you're affiliated with the Rosedon Holding Company Limited Partnership, is that right?
Yes, that is correct.
And you are the Vice President of Development of that company?
Yes.
And just briefly, what is your experience in terms of the development process here in Radnor Township? What have you done, and who have you worked with?
Over the past 10 years, in addition to being employed by Rosedon Development, I was formerly employed by a company called Penn Real Estate Group, which is run by a guy named Sean McCluskey. Sean, during my time with him, redeveloped numerous properties, well, 3 properties on Route 30. One of them would be 3000 BC, which used to be the Farm Mart, next to the Bertucci's, which we built as well, and the Piece of Pizza across the street as well.
All right, so you're familiar with Radnor, and of course you're familiar with this project located at 147 Pennsylvania Avenue, is that right?
Yes.
And in fact, your office is located adjacent to this project, and so you see it every day, is that right?
We are immediately across the street, and I see it numerous times a day, yes.
Now, can you tell the board why this project is important to your company in terms of its list of development projects? Is it near the top, and why?
Well, Rosedon Development currently has about 25 properties, a number of them in various stages of redevelopment. This property is particularly important to us, number one, because it is right across the street, as Mr. Brennan has said, but in addition, it's being an eyesore in the community. We are extremely interested in improving that neighborhood in there.
Now, when this project was originally proposed, was it going to be a spec project? That is, was it to be built with bank financing and then set up so that an operator would be found later?
We had originally planned on developing the property as a spec public storage facility. Since that time, as you all know, the economy has gone south. So not only has it been difficult for us to lend, to borrow, the potential tenants that we are trying, the alternative to building the spec building ourselves is to go out and get an equity partner or a tenant. And we've been going down that path, but as of right now, the lending environment, even for those tenants, has been very difficult and improving.
Have you been actively attempting to locate an operator which would sign a lease with your company, which would then enable you to obtain the financing that you might require in order to go forward with this project?
That is our current plan now, is to sign a contract with either large or regional operator that allows us to then come in for land development process.
Have there any, that's the plan, but have there been any efforts, any conversations with potential tenants?
There are numerous tenants that are interested. We have not been able to get past an LOI stage with any of them as of now. Although there are numerous parties interested, we are hoping to be able to finalize something this summer.
And if you had a lease and a strong tenant, would you move ahead promptly with the development process?
That's all we need.
And does your company have, you don't need to be exactly particular, but a huge amount of money invested in this project so far in terms of planning and designs and architects and lawyers to get the project to its position now of having been granted relief?
We have a significant investment in the property as of now through legal costs, design costs, environmental costs. I couldn't give you a number though right now.
I don't want to get too deeply into the whole history of the application process, but this is a site that was an oil company.
I think we recalled that, if I may interrupt you and cut you short a little bit here. You said that it was a spec building. That is not what I recall from the testimony, and we're actually looking through the notes now.
You were going to operate it yourselves, I thought.
Yeah. Build it on spec and operate it ourselves, absolutely, yes.
But from what I recall, the gentleman who was testifying said that there were many people lining up that need this type of storage, because I question the feasibility of expensive storage space when there's so many others around in the area in King of Prussia and so forth. And he said there's plenty of people waiting for this type of storage space for their antique cars and so forth. What happened?
We still believe that market is there. It's just a question of we can't build it. We don't have the resources to build it as we had originally planned.
Well, my concern is, situations change, neighborhoods change, traffic patterns change. How long, John, do we carry this continuance forward or an extension of time forward without revisiting the whole property again?
I believe that is within the province of the board, and with an approval this old, I think at our last meeting, we acknowledge that the economy is difficult right now, but that by itself doesn't carry extensions over indefinitely. Fundamentally, this board is concerned with zoning, and the zoning is land use and land planning, not an analysis of the economy. And at some point, even if there are economic hardships imposed by the economy, this board is free to say that, look, things have changed, and if we're going to continue with this project, you would have to come back to us and be reheard, because too much time has passed. And I think that was the message that we gave in April, and is, to me, very much that's what the board is supposed to be doing. It's not consistent with what the board's supposed to be doing. The board is supposed to be functioning as a land use adjudicative body and making its decisions on those bases.
All right.
May I
Yes.
comment on that? I'm sorry.
Yes, please.
There's nothing in the MPC that in fact requires there to be deadlines tied to grantings of relief, and in many communities and municipalities, there are none. In fact, Radnor's 6-month restriction is a little on the restrictive side, which is fine, but I just want to note that there are many situations where there's no restriction at all. As if you go in to develop it, then you use the benefit that you've been granted, but if you don't, then you never use it. And that the corollary argument there is that they're really, in our view, I understand you need to keep track of everything, but in terms of the relief that was granted, we would respectfully argue that there's no real harm to the community in terms of giving the applicant a little bit more time, especially in this environment.
Well, there could be if it's carried on forever, because
with that, but-
there's other development that's happening on the other side of the bridge, and that could change traffic patterns.
I understand.
And a different situation, or there could be a development on that side also. And it was very specific, variances were given. So it's not like a subdivision where the ground was divided and, okay, it can sit there for 10 or 15 or 20 years or forever for that matter and later be developed according to code. But there were specific variances given for this specific building and this specific type of development. Do other members of the board have questions or comments on this?
Yeah. But first of all, the issue of whether everybody has limitations like this, I mean, that's really something you need to address to the legislative body, to the commissioners. We're bound to deal with the statute as it exists, the ordinance as it exists, and it's a 6-month limitation. On the other issue, we've had discussions among ourselves on this topic generally, not necessarily in relation to this particular application. And I probably feel the strongest about this of anybody here, and that is that circumstances change. The last year has taught us that, if nothing else. And when you give a variance, you consider a lot of things. You consider facts, evidence put in, objections made by the community. You consider recommendations made by township staff and all the things in granting relief. And the relief was granted in this case. I wasn't on the board then, so I don't speak to the issues of this case. But after time, things change. It could be other developments that may change traffic patterns or burdens. It could be changes in the ordinance. You can't really take a variance and put it in your pocket forever and use that as one of the things that adds value to your property. You have to act on it within a time period, and that period has already been extended. Now, if things don't change adversely, there's no reason to think that you wouldn't come back for the same relief as before, and that it wouldn't be granted if circumstances have not changed. But if other testimony is developed, other evidence appears, changes in the community occur, change in the law occurs, we need to be able to consider that in order to protect the community's interest. We can't be held to the past circumstances while you get the benefit of the future circumstances.
I understand that, and we respect that completely. However, the world has changed. And the problem with arguing the economy is it just gets jaded. There is the economy, and people finally say, well, we know the economy. Now give us some other reasons. But the truth of the matter is nobody is buying, nobody is developing, and the banks aren't lending. And that is the principal reason. It's tied to the
Well, we're not accusing you of dragging your feet. I think we all well understand why your project has been delayed beyond the original time frame. It's just a question of what's the consequence on the variance relief that this board has granted. But we understand why it's not going forward quickly.
Our main point is this is a good project. The property as it sits now is in an unused oil company parking area. And we had developed, I thought, an extraordinarily clean architectural design for the building. So there was to be a significant upgrade, and they want to do it. This is a top project for the company. They want to spend a lot of money at that site. And through no fault of their own, things are just jammed up a little. They're not the only development company in Radnor or in this area that's having this kind of trouble. I would say that a company that's not having trouble would be the unusual example under the circumstances. We understand what has to be done. There's a lot invested in this project. It's very important. These are Radnor businesses. Their property is right next door. They need a break, and we're asking for your consideration of the enormous expense that's gone in already. The fact that when you have a benefit of a variance, it's a horrible thing to lose or to waste. I understand we can come in again, but there was a parade of witnesses and experts and environmental experts and traffic experts, and it was an expensive proceeding to put on.
Well, excuse me, sir. When did the variance run out?
Well, it was granted 10/30/08.
So it ran out last month, and we extended it for a month.
Yeah.
But that was, I believe, the second
Third.
time that they requested.
I mean, is there any reasonable
extension.
expectation that this will march forward in some significant way in a month or 2 months?
Well, we're asking for 5 months, and I can't promise that.
I mean, why not a year? I mean, what's the significance of 5 months?
We're
Well, I think
doing the
we,
best we can in a difficult environment, and
I mean,
I think this board traditionally has been comfortable only with 6-month extensions as a matter of our practice. They came in with a 6-month extension. We wanted to hear more, so we gave them a month to come to us tonight, and we have the other 5 months left if the board wants to grant it. And there's 2 questions. One, does the board wish to grant the additional 5 months? If the board does, that doesn't mean that this isn't, if they should come for another extension at the end of that 5 months, if the board isn't free to say no at that time. It is true that in the absence of a legislative directive to the contrary, variances run with the land and do not expire. But the commissioners have put that direction in the zoning code, that it's 6 months unless extended. There clearly is a policy directive in the code to not have these go on forever. And the Pennsylvania case law clearly upholds that kind of a limitation. And particularly where we've gone now, if the extension is granted for a 2-year period, I think that we certainly, if you granted this extension, we've gone well beyond anything that could be thought of as something that, just give us one extension or one chance. The economy is bad, and there's no question about that. And I agree that this isn't a case of dragging heels. The economy is terrible, but that doesn't mean that the board cannot or should not exercise its discretion based on land use principles, changes, and the thought that maybe too much time has gone for whatever reason. It's not a matter of fault to allow it to just be continued any further. So that's how I read it. I think the board is free to grant this extension for 6 months without binding it to self to do it again. And I think that the message that we made in public at the April meeting is that the economy is a real factor. We understand people are caught in it, but that can't bind the hands of the board indefinitely.
What does the board think?
We're still talking about a storage facility and office facility, right?
That's right.
I thought I read something to the effect that one of the business industries that is increasing is storages, because as people lose their homes and different apartments, they're storing their stuff, as opposed they have nothing else to do with it. I mean, I would have to think that what you wanted to do would be an up industry right now.
But that might not be expensive storage,
Well,
the type that they're
Yeah,
talking about.
and
People are selling their expensive
I had an
toys,
issue.
not
I had an issue with the kind of storage they were
Yeah.
going to do the first time they came in, and I think they altered that a little bit from what they weren't going to do the same thing. I thought the second time they came in, and we didn't give them the parking needed or something. They said so. They came in and they revised. I thought they had revised it.
Right, there
and
was a turn down
downgraded
in
from
a new project.
an upscale place to a more moderate one is from my recollection, I think, Jim, right? Wasn't it?
I think that's right.
So, I don't see why why you haven't moved forward, at least with the storage portion of it. I can understand the office portion, but the storage portion seems to be an industry that kind of holding strong, I think.
Well, it's the same building. I mean, you can't, it was all in one unified building project.
I thought,
And
It
the
was
model
one
probably
building.
assumed both as opposed to just
All right.
one.
right.
Well, let's make a decision on this. What does the
Well,
board feel?
I'm willing to grant another 5 months, but I think you need to be aware that we don't know what you're going to come to at that stage of the game.
I would agree with that.
Okay, yeah, I would do the 5, but I'm not sure today that I would pass this extension.
I would go with another 5.
I do agree
All
with the frame.
So we'll grant the extension of a total of 6 months, counting the one last month for 5, which would take it to, where are we?
October 30th, I guess. Yeah.
I guess, yeah.
Or the 29th or 30th. Thank you all very much. We appreciate
Thank
your
you.
consideration. Good night.
One other item before we start with the agenda, we received a letter from Kaplan Stewart via electronic email today, addressed to John Ryan regarding the appeal of PNC Wealth Management, 200 West Lancaster Avenue. Dear Mr. Ryan, I'm writing to you in the capacity of solicitor of Radnor Township Zoning Hearing Board. My firm has been retained as co-counsel for PNC Wealth Management, the applicant in the above-mentioned matter. A continued hearing on the application is scheduled for this evening, May 20, 2010, as we discussed earlier today. I'm writing to you to request that the hearing be continued to the board's regularly scheduled hearing date of June 17, 2010. As we have discussed, this request is necessary to permit PNC the opportunity to prepare testimony and evidence to respond to the issues raised by the board during the February 19th meeting in this matter. Please also accept this letter as PNC's grant of an extension of all applicable periods of time persuaded by Section 908 of the Pennsylvania Municipalities Code, Planning Code 53 PS 10908, within which the board must conduct hearings and render a decision in this matter. Nick Nealia, Esquire, co-counsel for PNC, will be present this evening to reiterate PNC's request for a continuance and to respond to any questions. However, in the interim, you have any questions, please contact me. It's signed Craig Robert Lewis. Nick?
I really have nothing else to add. I think the letter speaks for
Okay.
itself unless the board has any questions.
Okay. Any problem with that on the board here? We continue to next month? All right. So that is the first item that was on the agenda tonight, 2826, which will be continued to June now. Okay, getting back to our regular agenda, Appeal 2828, the applicants James and Leslie Ryan, located at 8 Duncan Lane, Bryn Mawr, PA, zoned R1, seeks to complete a renovation on the corner lot, which is impacted by 2 front yard setbacks. Proposed renovation will result in an encroachment and setback by the corner of the new front porch, a corner of the new family room, and addition of a 2-car garage as an accessory building. Area of encroachment is 2.7% of the setback area. Applicant requests de minimis variance from provisions of Section 280-15C. This is also continued from April. Yes, sir.
Good evening. My name is Joe Ryan, and I represent my brother Jim and his wife Leslie. I want to apologize again for dropping the ball last month regarding the postal notice, and thank you for the continuance. I'd like to hand out an exhibit packet.
Did we number your exhibits last month?
We did not.
We did not. Okay, why don't we do that first then? How do you want to do that? This packet you just handed up, do you want to,
I can go through that and identify them.
well, did you want to number the different items separately in here?
That they're numbered as their tab.
You just want to be A, 1, 2, 3, 4, and so forth?
It'd
as
be
their tab?
A1, yes.
Okay.
A1 would be the application.
Okay,
A2 is the legal notice. That was of the original hearing on April 15th. A3 is the deed dated March 30th, 2005. A4 is the plot plan entitled Residence Addition for James and Leslie Ryan by Glenn Arthur Ritter, architect, and it's actually AS1, and that's the plan that I have here on the table, and it was part of the application. A5 is again plans by Glenn Arthur Ritter entitled EX1, A1, and A2, and you'll see that they are the floor plans for the proposed addition. A6, again, are plans by Glenn Arthur Ritter, architect, and they are captioned garage A1, and then residence A2, and they are the elevations of the proposed residence. A7 is a letter signed by all the surrounding neighbors, and my brother Jim will testify as to who they are. And
Is your brother, are either of the owners here tonight?
yes, he is.
Great.
Come up here.
Thank you.
You want to have him sworn now, or?
Whenever you're ready, but we will need to swear before we start testimony.
Before we-
Well, let me finish through these.
Yep.
A7, as I said, was a memo to the zoning hearing board regarding this application, and it reads, "We, the undersigned, have reviewed the above application and are in favor of the requested relief," and that is signed by the surrounding neighbors.
Now, in the items that were given to us before, we have photographs, a packet of photographs. Are they duplicated?
Yeah, I would like to identify them as A8.
A8? Okay. And the whole packet would be A8?
Yes, we could go A8, A, and I can identify them.
Okay. You don't have to identify them right now.
Okay.
Mr. Ryan, is the large plan here the same as the small plan A4 in your packet, or is this a different?
It is, Mr. Ryan.
Okay.
Yeah, it's identical.
And what was the letter on that one? The
A4.
AS1?
Oh, the exhibit number is A4, is it not?
A4, okay.
Oh, yes, A4 in the packet.
Okay. I think do we have everything?
Yes.
All right.
We're here tonight to seek a variance from the setback provisions of R1. As you can see from this plan, this is a corner lot at Shannon and Duncan Lane, and it's burdened with 2 front yards. Their address is actually 8 Duncan Lane, where their front walk presently goes down to Duncan Lane, and that's the orientation of the house is actually right to the corner, and the front door is to the right of the house and leads right down to Duncan Lane. As you can see from the architect's drawing on AS1, the home, as it was built, is built right to the edges of the setback lines. And then, in the back, they have a concrete patio and a swimming pool. It's burdened by 2 front yards, so obviously most of a good bit of the property is setback. I guess a strict reading of the ordinance would require 5 yards for this property because you need 2 side yards and then a rear yard. In this orientation, the side yard would actually be behind the house. And the rear yard, as the building setback line was originally drawn, is opposite Shannon Circle behind the pool here. That would be the rear yard setback. If the front yard had been Duncan, we would only need relief for that front corner of the porch. And I'll explain the proposed additions. As you can see in your packet, Mr. Ryan would like to expand the use of his house, and he wants to convert his garage into a family room and move that forward. He wants to put a front porch on his facade of his home at the front door, and to keep it geometrically even, that corner of that porch encroaches into the front yard. If that actually were a side yard on Shannon Circle, we wouldn't need relief for the corner of the family room, but as it is, it is a front yard setback. So the proposed garage is an accessory building, and that needs to be 10 feet from any property line, which it is, and more than 10 feet from the house, which it is. But according to ordinances, it needs to be in the rear or the side yard. And technically, even though that would be a side or a rear yard, because it's a corner lot, that's a front yard. So we are, with the proposed additions, we're still well within the impervious cover restrictions of the ordinance. My brother Jim and his wife contacted all the neighbors, received signatures, showed them the plans, received signatures from all the surrounding neighbors. The only neighbor that we don't have signed on here is the neighbor on your plan that says Arthur Beebe. It's right behind. Jim talked to Mr. Beebe, whose house is under agreement of sale. He didn't think that because he had sold his house, he didn't think that he should be the one to sign. Jim then contacted the new buyer, who also had no objection, but didn't think that because he didn't own the property yet, he didn't think he should sign. But they've indicated that they have no objection to the plan.
And in any event, the requested relief is not in the rear of the property, it's in the front.
I'm sorry?
In any event, the requested relief is not adjacent to the BB property, but rather is in the front of the house.
Right.
As I read your plan, the property faces Duncan, but for the fact that you also are facing Shannon, your proposed addition facing Shannon Circle, if that were a side yard, would not require relief.
Correct.
But you still would require relief under any scenario for the 8-foot intrusion towards Duncan, even in the absence of the other street. Is that not correct?
Correct. And as you can see, the way that the house was oriented by the original builder, each corner of the residence is exactly on a setback.
Yeah.
And behind the house is the pool and, of course, the rear yard setback. So there's no way to, improve the use of this house or expand it anyway without asking for that in the front. Now, the intent of the front porch is obviously because if you're familiar with this property, it's a little bit up on a hill, and I can go through those pictures. And it's, right now, they sit on the front yard, and the kids play, and the neighbors go by, and they thought this would be an appropriate addition to the house.
You do not need any relief for impervious at all,
None.
either as to the building or as to the total aggregate impervious?
No.
You're within both of those limitations, the
Yes.
15% and the 22%?
Correct. And as a matter of fact, that's set forth in AS1. The proposed impervious, the existing impervious cover is right now 16.08 of the net lot area, and that will go up to 19.07 of the net lot area.
Yeah.
22 is the
The
max.
building piece is not broken out, but I assume the building would be under 15% even with the additions?
Correct. Maybe you want to swear witness in.
Yes.
Would you raise your right hand, please? Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Mr. James Ryan, I guess, do you adopt as your own testimony the statements made by your attorney so far?
And
Got
Jim,
a lot of Ryans running around here.
yeah, right. The record will be a little mixed up. Jim, can you explain to the board what your ideas were with trying to expand your home?
Sure. It's, funny thing happens when kids get older, they get bigger, they take up more room. We have 4 children and plan on living in this home for the rest of our lives. And one of the things that we enjoy about the home is the front yard. Originally, the front yard was the backyard to a big estate. And what we enjoy is we selfishly get the nicest sunset north of Key West on our front yard. So Leslie and I would like to enjoy that on a front porch, as you can see in the plan. Additionally, the family room area that we currently have is quite small. And I am one of 8, my wife is one of 5, and we entertain quite often and have many family gatherings. So as we would hope, as our children grow and they bring their children over, we have some room to spend some time with them and to entertain. And then as far as the garage, I like to tinker, and I have a tool set and do some work, and I'd like to, be able to store my cars and my stuff and spend the rest of our lives in that home.
Jim, did you talk to all the neighbors and show them the plans?
Yes, we did. In fact, we had a gathering with our neighbors to show them the plans. For those that couldn't make it, we walked around and met with them individually. As you can see in your packet, we have a list of neighbors and their signatures. They all do feel that this development itself is about 32 years old, and none of the homes have had any major renovation. So they feel as though this would increase their own property values with their own homes.
Jim, why don't we just identify what we'll show as the photographs which are marked as A8, and just describe what that is, what the view is.
This is actually a view standing in the corner of the property, which you would see right next to this sycamore tree. See the branches there. And this is really the view from the corner of Shannon Circle and Duncan Lane. These two windows here are the existing garage, which we would like to bump out. And then this view here is where we would like to set the front porch. The front porch will be made of ASAC. It's not a concrete or flagstone porch. This view here is this side of the house. So the view from the fence, the front yard looking up at the front of the house. The porch would sit right in this area. This actually is the view from Shannon Circle. So as the plots would say that this is a front yard, this is the rear entrance, or the entrance, the driveway entrance, off of Shannon Circle to the home. We'll convert that garage area into a family room with a back entrance. This is the view of the property line from Shannon Circle between my property and Arthur Beebe's property here.
And that's where the garage would be
Yes.
proposed?
The garage is proposed here, 10 feet off the back line of the property. This is a view of the side of the house, right about here. And this is a view of the back of the house from behind the pool right here.
And lastly, Jim, do you believe that the addition that you're planning and the variances that you're asking for will have any adverse effect on public health, safety, welfare? Or
Not at all.
do you think that your additions will be in keeping with the community?
Yes.
Okay. That's all I have.
I have a question. Are you seeking relief as to the new garage?
I'm sorry?
Are you seeking any variance relief with respect to the new garage?
Well, we're not, because we're keeping it 10 feet as required from any
Right.
property line. It's an accessory use that can be in the rear or the side yard.
Oh, I see.
So technically, that's a front yard.
I see. Okay.
The-
So
the-
you technically need a use variance there.
Right. But if you would
Well,
consider
dimensional
that,
variance.
Oh, it's a dimensional. You're right.
Yeah.
My apologies.
Now, I think the bottom line is that the garage and the portion of the addition towards Shannon would not be required if they, if Shannon Circle wasn't triggering a second front yard.
Got it.
However, even if Shannon Circle didn't exist and they didn't have a front yard issue there, they clearly would need front yard setback relief for the portion of the property, of the property that faces, the addition that faces Duncan Lane.
that corner of the porch.
Yes.
Right.
Can you make that porch 2 feet smaller instead of 10 feet, 8 feet?
2 feet.
2 feet
Closer
shorter
to the
that way,
house.
closer to
2
the
feet
house.
short, no, the porch is 10 feet, 10 foot deep now,
Yes.
to make it an 8 foot deep porch.
I think in keeping with the architectural,
I understand all that. Can you make it 2 feet smaller?
I don't know how that would affect the pitch of the roof, and I think that's what he was trying to accomplish with the look. Could you make it 4? Could you make it 3? I guess you could, but
Is the porch going to be covered?
yes. If you can see in your packet, I think it's A6. You see the elevation of the proposed addition.
Yeah, it's not working. If this is what we're looking at, the front? No, I don't see the back.
You can see the front, where it says front elevation on the A2.
Oh, I see.
So I think that what he was trying to do was, with the pitch of the roof and the pitch of the new roof over the family room, course, I was absent in law school when they did pitches of roofs, but I imagine that's what he's doing. To answer the question, I guess technically you could make it 9 feet, make it 8 feet, but I don't know how that would affect the,
So the pitch of that little roof over the new porch is going to match the pitch over the present garage, new family room? That's all going to be the same pitch?
If you see here, the pitch of this roof here,
All right.
would match the pitch of this porch here.
And the slope coming toward you from over the family room? That's all in the same pitch, they're going to match up?
No, that would be steeper.
This part's steep.
Oh, that's steeper than that?
This matches this.
So there is a break there. Well, that could be any depth they wanted, just by changing the pitch of the little roof over the porch. It wouldn't match. But I have a question. Would you say that your house is not reasonably usable as a residence in its present condition?
My wife would disagree with me, but yes, it is. It's useful.
It's usable, it's reasonable, it seems like a very nice house to me. I just trying to establish what the hardship is, to justify granting 3 variances.
well, I submit that, first of all, I submit that this is the hardship here is the irregular shaped lot and the impact of the.
Is the lot irregular? The lot's not
Well,
irregular.
it's
Yeah,
2
it's
front
a corner
yards. It's
lot.
burdened with 2 front yards.
But I mean, that was that way when they bought the house. I mean, that's the
Correct.
existing condition, it's common.
Right.
And
But
it's
I
that way.
would submit to the board that this is a de minimis variance. We're only asking for an encroachment of 2.7% of the setback area. And I think.
Well, that's if you look at it by area, but actually setbacks are determined by depth, not by area.
Well, it would seem that in
Well,
this
let me
case.
give you an example. You have your existing garage, and you want to make that into a family room. That makes sense. But then you're extending it out even further, and that's what's creating one of the encroachments. The garage itself isn't big enough. You want to take that, make it a family room, and then make it a lot bigger than it is now. Is that necessary for the reasonable use of the property as a residence?
Well, if I could just tell you, this garage here is just over a 1-car garage. You can't fit 2 cars in that garage.
I don't see dimensions in this plan. I was trying to find the overall dimension
They
of
have
what
just
the new
the-
family room would be, the
The
length.
new addition to the family room,
Not just the addition, but the entire family room.
On A2, which is, I'm sorry, in the corner, it's A6 of my exhibits, but it's
Well, I was looking at the larger plan here, which is A1, labeling of the plan. I'm not sure exactly which exhibit it is, but it gives the width as 21.5 feet, but I don't see, and the extension 16, but I don't see an overall length
Well, I
of
think-
the room.
I think the way that they can add it up, if you go 16 feet back to the front yard and then 30 feet, which includes the
Probably,
mudroom and
Kathy,
laundry.
it's probably 38 feet. Most garages are 22 feet deep.
Okay, so 38
Yeah.
by 16, that's, or 21, that's a big room. Could you squeeze that back a little more? See, we'd like to help you out here, but this is really big, and it's going over out of the building envelope a lot. And,
I can't say that, I would have to
Except for
advise
that
the board
area,
that these
so
are
that
not de
area is-
minimis variances.
Are being closed.
Just, they're too big. They're too big.
Yeah, but they're only doing one.
Particularly the one facing Duncan Lane, and the board has on occasion granted, recognized that the 2 front yard rule has imposed, is tough and has seen hardship, particularly where the board has found some physical aspect of the property, such as configuration of the house and so forth. But even with that, if that kind of latitude were to apply in this case, the one on Duncan, that's an 8-foot extension into a 60-foot front yard, and even if there were no front yard on the side, that front yard would be there, and that's beyond a de minimis extension in my view.
Well, I submit that I had a prior case in front of this board for a resident, Martin Marshall, and it was the same exact situation. It was a corner of a house, and it extended into a rear yard. And we discussed at that time that a setback area is not linear, it's spatial. And if we were to ask for an 8-foot encroachment into the front yard, that was the length of the building, that would be a bigger encroachment than what we're proposing here, which is an 8-foot triangle. And
That's
the
a
board
good
at that
argument.
time.
That's a good argument, but I got to tell you, I'm not buying.
I'm just saying
You know, there's an envelope that you're supposed to stay within, okay? And you've encroached the envelope. You're asking for 3 additional ones, and I think you even
Four,
encroached
actually, four.
four. And
Which
I
is a
think
covered
you've
porch
even
on the side.
encroached the pool flagstone at the bottom as well. So, you know, you're asking for more.
I'm sorry, where?
The pool exists, doesn't it?
Yeah, the
Yeah,
pool
yeah,
exists,
pool
but
exists.
it still encroaches, regardless of whether it exists or not. That's another, what I'm saying is that,
Well, that's an
is
accessory.
that you have to,
That's an accessory. I think it can go within 10
I
feet of
don't
the
think
line.
The pool is
Um,
okay, maybe.
in the rear yard.
I
That's an
just,
apron.
yeah, I just think that the job of this board is to give the minimal amount of relief necessary under hardship conditions. Okay, and like Noah had said, where is the hardship that allows this board to grant you 4 separate variances in the home?
The hardship here is that you can't add anything to this house without some encroachment.
But you have a 5,000 square foot house. I mean, a 5,000 square foot house is not a little house. I mean, what he's saying, you know, what Counselor is saying is that you can't add anything to the house without going outside the envelope. Okay? And what we're saying is, we understand that, okay? And one of your hardships is that you're on 2 frontage streets, so therefore you have some issues relative to that, okay? But the ordinance doesn't allow for, the ordinance says specifically about front yards is that no matter how many front yards you have, on each street that you front, you need 60 feet. I mean, it's in the ordinance. So when the house was designed and built, and I don't know when it was done, whether it was under this current ordinance or a previous ordinance, okay, the builder stayed within those guidelines because that's what the house. And he placed a house, okay, he placed a home where he thought it was going to have the best sale appeal relative to who was going to potentially buy the home. You know, side yards, rear yards, whatever the case might be, okay. Future owners may not like what he in fact did or she in fact did when they built the house, okay? But you still have to stay within the guidelines of the ordinance. That's what our job is, okay? And we're to give you relief, the minimal amount of relief based on hardship, okay? It doesn't mean that we have to give you everything you want, exactly how you want it. You know, creature comforts don't necessarily play into what we have to do, because if we gave everybody everything they wanted, you know, why have a book? I mean, everybody would just build and build and build, you know, and that's not what our job is.
I think what we're asking is, can you reduce the encroachment a little bit? You know, we understand you have a problem with 2 front yards, but can you pull both of those back a little, possibly the porch and the family room a little bit, so that you don't encroach as much as you are?
Well, the other thing is, what about the garage, which if that were treated as a side yard would be fine, but the entire garage is going to be built into the Shannon Circle. Isn't that correct? The entire garage extends further towards Shannon Circle than the proposed addition does, and the entire garage is being built in that front yard. I mean, I don't know if there's an argument to be made that the placement of the house as it exists now, coupled with the 2 front yard thing, would justify relief towards Shannon Circle. That's for the board to decide. I've seen less of a case made, though, for the extension towards Duncan Lane, which even with the, you know, if this wasn't a corner lot and Shannon Circle didn't exist, there'd still be a front yard, and that's an 8-foot encroachment into a 60-foot yard, which is not de minimis.
Is it 8 square feet here?
It's an 8 feet, it's a 60 foot.
Measuring from the corner to the property line.
Well, it seems as though you're looking for, if we're right, 4 spots. The corner of the front porch, the corner of the garage,
Well, the extension of the garage corner.
the
What will
extension
be
of
the
the...
new family
yeah,
room?
The
corner of the-
darkened triangle here
Right,
on the front porch.
yes.
The darkened triangle on the family room.
And they're
Family
right
room,
next
I
to
mean,
it,
yeah.
too.
Then the deck, is that a deck that's
Isn't that a
next to
covered
that?
porch there?
No, that's a, what you call that, a parapet? You know, it's not, it's just over the door,
Okay, so that's not an issue?
No, it's
Okay.
not an issue.
So those 2 issues, and then the garage.
and then the garage, if that's.
I think what you're gonna have to do, to put it simply, you're gonna have to shrink them. Now, you have to decide how much you wanna shrink them. Remember, it's our job is to give you the minimal amount of relief based on the hardship that you propose to us. You know, it's not to give you everything you want, unless everything you want is a hardship enough that we deem that that's something that adversely affects, whether it be a triangular or something in the lot or something that's there, okay, that to make it really habitable and livable for you or anyone else, we feel that's something that we have to do, to make it. But remember, like I said, you have a 5,000 square foot house. It's
Well,
not a little thing.
I'd like to give you everything you're asking for, because I think it looks terrific. I think it's a great plan, but I think it's outside the scope of what we're supposed to do.
Would you
So
like to
I would recommend you
take a
go
few
back
minutes?
and work on it and see what you can
Or
do
come
to
back next
We
month?
can,
Help make it better
if we
for
can
us.
continue it, we'll go back to the architect and
Okay.
see what he says.
Yeah, because eventually, if you make any kind of major changes, it's going to have to be reflected on the plans, and we're going to pass or reject what you do based on the plans. And it's going to say that in what John writes, that, based on the plan, we give you the variances that you asked for. So,
May I ask for a clarification on the facts, just for a second? Next to in front of the present garage, you're converting that into the part of the great room, and it's going to have a door going out. Is that rectangle here, is that an open patio on the plan? There's a rectangle there.
It's just a parapet. It comes over the 2 doors.
It's more the parapet. Parapet is a wall that goes up above the roof line.
I'm misspeaking.
In other words, it's roofed. Is it roofed?
Yeah, it's a roof. You can see it on the,
So the roof comes out beyond the wall of the present garage?
No,
That's an extension? That's what I'm trying to figure out what it is.
I can show you here. This roof line here,
Right.
Can't hear you.
this roof line.
If you could use the mic there and lean into that.
Can everybody see that? Okay. The idea was to extend this roof line over here so it would cover the back door.
And that's going to have a pillar holding it up and a roof above it?
Yeah.
So it's going to be like a covered porch?
it is, it's a covered.
But it's already there.
Well, it's going to have a slab under it, it's going to have a roof above it, it's going to have a pillar holding up the roof, it's a covered porch. So that's another encroachment
Well,
right
I
there.
don't think you would, sit on it.
Well, this is how you, I don't care if you just look at it, if it's a structure, it comes under the effect of the zoning code.
Matt, can you comment on that?
Is the question, will the covered portion but doesn't have walls,
Yes.
is that a structure? No, that part's not going to be considered the structure.
Okay, thank you.
Even if it has a pillar holding it up, and a
That's
slab
correct.
and a roof?
That's correct.
Okay, then I'm corrected, sorry.
I'm sorry, Matt, what did you say?
That will not be considered a structure. If it's not enclosed, if it just has pillars, now it could sometime be enclosed, okay, then it would become a structure.
At which time they would need relief.
Correct, but not at this point.
Well, if that's the case, then why wouldn't a porch be treated that way?
A covered porch,
Yeah.
I'm sorry, what, I thought we
Well,
were.
basically, it's going to have a roof, it's going to have a column holding up the roof, and it'll have something on the ground, like a slab or, some sort of hard material.
Mm-hmm.
How is that any different than the front porch?
Well, it's picture entering a house and you have a covered
Well,
area.
that's what the front porch is.
Right, that's.
So why does the front porch encroach and not the side thing?
Well, if that's the case, then we wouldn't have porches anywhere near in the front yard setback at all. The building would have to be set back, and then the front porch would have to begin where the front yard setback is.
Yeah.
that-
Yeah,
that
I agree
line.
with you.
That's
But
right.
why doesn't that apply to the side?
I'm looking at the definition, Kathy,
Yeah.
of structure. from the ordinance, an assembly of material forming a construction for occupancy or use, including among others buildings, stadia, tents, reviewing stands, platforms, stagings, observation towers, water tanks, trestles, piers, wharves, dams, open shed, coal bins, fuel tanks, shelters, fences, walls, flagpoles, communication towers, and display signs. Any man-made object having an ascertainable stationary location on or inland or water. So that's a structure.
But then if you also look at the definition of building, any structure having enclosing walls, roof permanently located on the land. It's not enclosed walls.
Yeah. But then
Well, let's
neither is
see.
the front porch.
Also says,
Correct.
the big thing is excluding cornices, eaves, gutters, chimneys, and steps, provided that they do not project more than 2 feet from the building.
Well, this does project
So
one.
this projects more than 2 feet, so it falls into it.
Yeah, I think that if this area here is not constructed, but
Well,
it's
I
gonna
wanna
be
see the
basically,
definition
you know,
of,
attached to the house and form part of the house.
can't have
I
it
do
in
think
the-
it's part of the building. I don't think that.
I don't see
putting
why
a
it should be treated any
colonnade-
differently than what
No,
the front porch
I think
is.
that's, if this area here, that comes out of that little, the corner of it is drain 393.78, if that is all gonna be a new construction there, with that door coming out into it, I would think that's part of the house.
And then you look at the definition of yard in the ordinance, because we're talking about the required yard. The required open space area around the inner periphery of a lot in which no principal building or structure shall be located. So you're not allowed to have a structure in the yard area.
This is a principal structure?
Except for principal
There's
structure.
no principal building
Yeah.
or structure. It doesn't say principal structure.
Well, it does if you then go to accessory structure, which is allowed in the yard.
Yeah, I don't know if it's allowed in the front yard.
Okay, where's the defined accessory structure?
Not in
But-
the front yard.
But it's
There-
attached to the
but
main
it-
building.
Yeah.
But if what you're saying is true, then the whole definition of accessory structure is meaningless if no structure.
Yeah.
I think an accessory structure is a separate structure. I think we've had this before, where
Building or
people have had a, you know, a corridor or something that connects an accessory structure
Oh, yeah, it
to a
says-
building, and then.
It's pretty well defined. A building or structure that is not
That
principal, not a
triggers it.
principal building or structure, and is used for purposes that are entirely incidental and subordinate to those of the principal building.
Like the garage you proposed, that would be an accessory structure.
Correct.
But this is not. This is attached to and part of the building.
But the accessory garage can't be in the front yard, I don't believe.
No, that,
Correct.
that's for
That's
another
only
reason.
rear- that
Under
was our
this
relief.
district, you're right, it can't be.
How far is this roof coming out? Beyond the wall?
Looks about 10 feet.
Does
No.
it need to?
If it's the same width as the porch.
Talk to the architect. This is a storage closet. If I'm able to use the accessory building for storage, we can move that portico share down to the corner.
It's now. Looks 8 to 10 feet deep.
Now 8 feet.
Yeah. Scaling it out.
So you can move it back here. Well, I can move it, so it just covers the door to here.
Yeah, you can move
Yeah.
it and stay within.
Yeah, that would be
one's
okay
an
then.
easy one.
Yeah.
That one's unique, because it's only like a little porch.
What I would request is that you grant us a continuance to come back next month.
Yeah.
Go to the architect, see if you can
See if it works.
fine-tune this, minimize it if possible. And
Okay.
if he can't, then we'll have the reasons for you.
I'm sure he will be able to minimize it.
You grant us
I have-
the.
I have faith in him and
Yeah.
you.
Extension
We-
of time
Now,
for.
what about the extension of the great room, creating that other corner that's?
Yeah, I think that needs to be pulled back a little.
I mean, it's an entirely new structure. Right
Right,
now, it's
yeah.
conforming, and it can continue to conform. They can
And
make a garage into a great room.
We've had some that have extended into similar situations, but they were very small rooms.
But haven't we granted exceptions
There was one
for-
recently that we gave, but the room and the way it was extending was not a huge room. It was still a very small room, even with the extension into the side yard or front yard, whichever it was, I forget. But this is a large room, a very large room, as it's drawn. It's beautiful, but see what you could do to pull it back a bit.
And you give us the extension of time for deciding the case and thereafter rendering a decision to start with the next hearing in June?
We do. And I'll find the case that I had before this board that specifically ruled that this, a triangle into a side yard of that dimension is de minimis. Because of the percentage, because of the percentage of the spatial.
I would be very, look, I think, first of all, Mr. Cutler is right that it's not binding, but I must have been asleep at the switch if I ever suggested to this board
I don't know.
that 8 feet into a 60-foot yard was de minimis. I must really have been on something that night, if I had anything
And I
to
think
do
a
with
de
that.
minimis, whether something
I
is
don't
de
know who
minimis
you were here,
depends
John.
on the totality of the circumstances.
Yeah, but I think 8 out of 60, my advice to the board is that strays beyond de minimis for 8 feet out of a 60-foot yard.
Thank you for your time.
Thank you.
Next is Appeal 2830, the applicant Jerry O'Connor, located at 302 Williams Road, Bryn Mawr, and is zoned R5, seeks relief from Section 280-35, area and height limitations. Section A3, front yard setback. Existing deck is to be removed and is 1 foot into Dreer Lane, is that?
Yes.
Front yard setback. The existing deck, 20 feet by 12 feet, is in disrepair and needs to be replaced. The applicant's new deck will be 29 feet by 16 feet, will decrease the front yard setback by 6 inches to 23 feet, 6 inches. The new deck will be built on the same line as the existing deck. The new deck cannot move from the existing line due to the location of the existing patio door from the dining room to the deck. Property is well screened by shrubs from Dreer Lane and Williams Road. Contention is construction of a new deck will have no impact on the aesthetic view from either road and will not have a noticeable effect on the front yard setback. Yes, sir.
Hi, exactly it. I'm just,
Do you have an attorney representing you?
No, I don't.
Okay.
This is the-
Then why don't we swear in everybody who's going to be testifying? Then, if you could give us your name, and if you could swear them in, please. Go ahead. Your name? Okay, go ahead. Your name
Jerry O'Connor.
and the other fellow's name?
Jeff Lenahan. Jeff Lenahan,
Can you spell that, please?
Lenehan.
All right.
Would you both raise your right hand? Do you both solemnly swear that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, before you start, how about we number your exhibits? Do you have any of them numbered, or shall I put numbers on them?
The drawing will label as A1, Exhibit A1.
Okay. So the drawing we have is A1.
Correct.
The application then, can we make A2?
That's fine with me.
Okay, the deed, A3.
That's fine with me.
And you have a plot plan with photographs attached. Why don't we call that packet A4?
Okay.
Okay, Mr. O'Connor, why don't you start?
Right now on the property, if you look at the pictures, I have an existing deck that is in need of a lot of repair.
That would be in packet A4, and is this the photograph you're referring to?
It
if you could hold it up.
says, deck to be removed
Are you looking at a photograph or a plot plan?
At the
Oh, okay.
photograph.
All right. How about we number them inside? And the order I have here, the first sheet is A4, and then this is a view from corner Williams Road and Drew Lane.
Yes.
We'll call that A4A. And then the next one is view from Drew Lane, photo number 2, A4B. And then A4C, that's photo number 3. And then A4, what letter am I up to? D.
D.
D. Deck to be removed. Okay,
Yes.
so you're referring to deck to be removed right now?
A4D.
Okay.
Yes.
Madam Chairman, I apologize, but I was fiddling with other documents. Just the application is A1.
No,
The drawing
application
is
is A2. The drawing is A1.
Okay, the deed is A3,
Yes.
okay.
And then the packet is A4.
A, B,
with-
C, D, and E.
Yeah, the first sheet is just A4, and then next is A4,
I
A,
see.
B, C, D.
Okay.
Okay, so you were talking about the photograph deck to be removed.
Yes. As you can see, it's in pretty much disrepair. It was there when I bought the house, and what I want to do is just to expand it 16 feet out and 29 feet long.
And you're, let's see, okay.
28101B1.
You're gonna decrease the intrusion?
No, we're going to increase the intrusion is about 1 foot right now. The existing deck, the corner of the deck that's in the front yard setback is at 24 feet.
And you're going to reduce it by 6 inches, correct?
No, we're going to
Increase it by 6 inches.
increase it by 6 inches
Right,
to
because you're going
23
from
foot.
20, you're going from 24 feet to 23 feet 5 inches.
Correct. The
Right.
deck right now is
They're gonna-
12 foot
It's
deep.
now 24 foot.
My client would
They're
like a
gonna-
deck
They're going
of
to increase it, right?
16 foot depth in the deck, but we have to keep the deck on the same line that it is now because of the patio doors.
Right. But you're only, you're basically not increasing the nonconformity that much. But you're increasing it by 6 inches?
Yeah, he's
Yeah.
increasing it by 6 inches.
Oh, now I call that de minimis.
The analysis is a little bit different, but
Yeah,
But
the
it's-
the
the
write-up
end
is
result
different
is the
than what
same.
is
Yeah.
what, right.
because it's.
That's
And
like
that's
a
the only
pretty-
relief you need for that, the 6 inches?
You don't need any impervious or building area or anything like that, no?
That's de minimis.
Yeah.
6 inches is
Okay. Does anybody have any questions?
fine.
Okay.
Noah?
Jim?
On balance, it's, I have no problem with it.
All right. Did you want to say something about your plan? You mentioned that the reason is that you have to go to where the door comes out of the dining room.
Yes. the
And you
existing
need,
door.
that's why you need to be on the same place you are, but you're increasing the depth of the porch, which puts you a few more inches into the side yard. Did I sum that up properly?
Front yard, it's a side yard, but it's a front yard.
Oh,
We
it's
have
a
to say- we have to
corner
say
lot.
It's a corner
deal.
lot.
Okay. But you're only increasing six inches
inches.
into the front yard, which is de minimis. Okay. All right. Did you have any, does the board have any additional questions? All right. Then why don't we move that your exhibits be made part of the record? Did you have anything further to say?
No, I don't.
Okay.
Do you have any neighbors on?
Any neighbors here that would like to speak to this? Yes, please, come up and identify yourself and be sworn in.
Patty Barker. Barker, B-A-R-K-E-R.
And we need to swear you in, please.
Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes. I live on Lewis Lane, which is around the corner from where Jerry lives, so I'm not an immediate neighbor. But I did want to come tonight, in case there are any questions by the board, just to say that, the neighbors are basically in agreement with what Jerry wants to do. His deck needs to be replaced, and the neighbors basically feel that 6 inches is not much more than what he's got right now.
Thank you.
Thanks.
Jerry, do you have any other comments?
No, I don't.
Okay. Then we'll close the record on this, and would you like to handle this, Charlie?
I would give him a variance on 280-35A3 in the fact that it's the de minimis request of only 6 inches increase in the, it's really the front yard, right?
One of the front
yards.
Yeah, the front yard setback.
Jim?
I would agree that a de minimis variance is appropriate.
Peter? Okay. Laura? I agree also, so it's passed.
Thank you very much.
I'm sorry, I don't know your name. Ann, do you need a break or anything? No, okay. Does the board need a break? Okay. Appeal 2831, the applicant Chung Sop Lee, located at 600 Brook Road, Wayne, PA, is zoned R2, seeks a special exception under Section 280-101B1 or a variance under Section 280-20D or E of the zoning code to construct an addition to their home. And the alternative, applicant contends the relief is permitted as of right.
Evening, Nicholas Cornelia, representing the applicant. Present is Sun Lee, who is the son of the owners of the property, and we do have a power of attorney in the
We do have a power of attorney in the
All right,
packet.
thank you.
And Jim Greenfield representing the neighbors, I'll call him out, and we've actually reached an agreement as to the situation here. And I believe, John, a couple of the conditions, one of which would be construction of a fence, and another of which is that it would exceed no more than 1 story, I believe could probably be added as conditions of any relief. And then we have another condition that will be separate from anything that the board could add, if that's possible. What we have here, we have a porch. We have a roof with, on the rear or on the side of the property, and what we're intending to do is enclose that roof. That roof in the house was built where the setback was permitted. It's a legal non-conforming use, and what we're intending to do is basically enclose the porch. It was an open porch previously, and our intent here is to enclose the open porch, so we're not going any further than the existing roof line. And so we'd ask a special exception for that. As I said, I don't know.
Do you want to go get Jim?
Yeah, let me go get Jim.
Okay.
Just to-
James Greenfield on behalf of Heidi Mertz, who lives at 342 Conestoga Road, neighbor to the immediate west of the subject property.
Okay, thank you.
And Jim, I put on the record that we would request, or any approval here would be conditioned upon the construction of a fence, as well as that the proposed addition would not exceed 1 story.
Correct.
And then I told them we have a separate item that we want
We
to
have
have a separate agreement.
Sorry.
We have another microphone there, like the handheld one.
Sorry about that.
No, it's handheld.
Do we know where the fence is going to be placed?
There's
Same
an-
location as the existing fence.
It would replace the existing fence, yes.
Okay, existing, all right, where is the,
On A5.
5? Where is the fence?
5. You'll notice there's an existing fence line. On the western, north,
Is that the?
eastern, northwestern side of the property.
Sure. Northwestern? I'm sorry, I'm missing the fence.
Where the
Sorry,
little
show me that
X's
again.
are, along there.
The X's?
Yeah, okay, I saw the X's, okay.
That's the fence.
That's it?
Yeah.
Yeah, but it runs basically along the southwestern 2/3 of the property, isn't that about right? Or it doesn't fence the whole property? Yeah, it goes from, it goes, yeah.
Yeah, we're, basically, it won't be part of this, but we're agreeing to some plantings that is going to cover it. But again, that's a separate agreement between us. That doesn't have to be a condition of here, because the plantings are going to be on Heidi's property instead of on this property.
So what you're saying is the fence will be rebuilt, the conditions are that this fence will be
It'd be a
refurbished and rebuilt.
6-foot stockade or similar type fence in the same location as the existing fence, and that the proposed addition would be no higher Will be a one-story addition, no higher than the existing roof line there, as you can see. Matter of fact,
Okay, hold on, let me get the first one down.
Also, the finished side of the new fence will face Ms. Mertz's property.
right. And that's a requirement
Yes.
anyway, yeah.
Right.
Okay, hold on, let me just do these one at a time if I could.
Did you say it was Mrs. Mertz's fence, or it's,
No, it's on,
it looks like it's on their property, but I thought you said it.
No.
The way the fence is built now,
it's on.
looks like it's Mrs. Mertz's fence.
No, it's
No,
on the
it's
subject.
inside.
Yeah.
It's inside.
Only because of the way that the stockade's facing. Usually you face the stockade to your neighbor.
It's an old fence.
It's an old fence, it's going to be replaced, but it is on, you'll see the line, it is,
Okay.
at least where it's located.
But I thought someone had said it's the Mertz's fence.
No, no.
Okay, now the addition is no more than 1 story, and not higher than existing roof line? Is
Correct.
that the condition? Width? No higher, roof no higher than existing roof line. Okay, let me read these back. A 6-foot stockade fence in the same location as the existing fence, finished side faces Mrs. Mertz, and then the addition will be no more than 1 story with a roof no higher than the existing roof line. Is that an accurate?
Yeah, I think the only other thing is that construction can't start until all these terms are fulfilled.
What terms?
up-
The planning and the fence, are you
Well,
referring to?
the fence,
The fence, yeah.
and there's another item
Okay,
too, but
it's not part of the
it's up
zoning.
to, if you can put it in, if not, we'll
Fence has
veto
to be
it.
done before, certainly has to be.
That's fine.
Before
The fence would have to be done before the
construction.
construction would commence.
Recommences, right.
There's room. They can do it. All right. So basically, you're looking for a
We're looking
variance
for a special
to the
exception.
side yard?
Where, to whether it be a side or a rear yard, to enclose the existing porch.
Wouldn't that be a 101B1?
Correct.
It's another 2 front yard day, huh?
Yeah, exactly. It's a corner lot.
But still 101B1.
Yeah. There is the plan shows previously existing patio. Is that currently there and has been removed?
This patio has been, yeah, that patio has been removed. yes.
Okay, and you're pulling it back from where that patio was?
Correct.
But
It's
expanding
going to
it.
be, yes. Correct? So, okay.
All right. I guess we should swear in
Swear,
your
ma'am.
witness.
And I'll go through the exhibits if the
Okay.
board wishes.
All right.
And then the board can determine if additional.
Yes, okay. Thank you. Yeah, could you spell your name, please, and give us your name?
S-U-N, Lee, L-E-E.
Okay.
Sun Lee.
Raise your right hand. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
And son, I've marked a number of exhibits here, A1 through A7, the first being the application that was signed by you, is that correct?
Yes.
A1?
Sorry.
I'm sorry.
A1 is what?
Is the application that has been signed by son, correct?
Yes.
And then A2 is the deed to the premises. Your parents purchased the premises in 1994,
Yes.
correct? And then A3 is the power of attorney from your parents to you to appear here this evening?
Yes.
Do you live at the site?
Yes.
How long, you've lived there since it was purchased?
Except for 2 years, yes.
Okay, 2 years,
Well, 6 years.
okay. You're at college or away?
Yeah,
or-
college in Hilton, Jersey.
All right. A4 is a copy of the Radnor ordinance in effect at the time that the house was constructed? And
I
the house-
think we need a mic closer to him, if you could.
Yes.
Thank you.
Sorry.
And the house was constructed approximately 1953?
Yes.
And I just marked as A4A showing that there was no prior relief for this site.
Yes.
And then A5 is the site plan,
Yes.
and it shows that you are enclosing an existing porch.
Yes.
And A6 is is a Google photograph, is it, or well, it says Microsoft, is it
It's
Google?
Bing.
Okay. And it shows basically the existing roof line?
Yes.
Correct, your house is where I'm pointing at here?
Yes.
All right, and you'll be enclosing this existing roof line there, correct?
Yes.
And A7 is just a photograph?
Yes.
That's all I would have this time.
All right.
Just request the exhibits be made part of the record, please.
Any questions from the board?
How old is this house, again?
1953.
1953.
What is A4A? Did you mention that? I must have missed it.
A4A was just a copy from the black Radnor zoning book indicating whether there was any prior relief granted for this site, and you'll notice under Brook Road, there is no prior relief.
Okay.
And also, I asked Mary Ann Cassidy to run it, and there was no prior zoning relief, even after the time this book
All right.
was not being kept.
No questions or comments from the board? Any further comments from the audience on this? If not, you want to move your exhibits to be
Yes,
part of the record?
I would request the exhibits be made part of the record, please.
Okay. Jim, you have that one?
It seems to me that a special exception pursuant to section 280-101B1 in this case would be appropriate insofar as it doesn't increase the existing nonconformity.
Peter?
Yep, I agree.
Charlie?
I agree.
Nora? Cora? I agree also, so it's passed.
Thank you.
Last item tonight.
I'm sorry. Subject, of course, to the conditions that were previously agreed to on the record.
Yeah, okay. Last item tonight is Appeal 2832. The applicant, Alberto, you're going to have to help me with this. Guagadini, I never would have gotten that. Located at 115 Stratford Avenue, Wayne, zoned R4 NCO, seeks to restore the property to its former use as a restaurant and bar. Applicant contends that the relief is permitted as of right, or in the alternative, requests a special exception under section 280-101A1 of the code, or a variance from section 280-29A of the code.
Thank you. By way of brief introduction, we have here Bob Patterson, who's the architect for the project, and Alberto, who is the owner of the property. You may recall, or maybe you don't know, but Alberto was the former owner of the Stratford Villa restaurant and actually the former owner of this property. He sold this property back around 2004 to Alona Takas, who came before this board for relief in order to establish a spa, a day spa. She never followed through with the permitting process. And also, there was an issue, and Alberto was forced to retake ownership of the property back about a couple years, 2 years ago. And now he's intending to reopen it as a restaurant, which was the previous use. Also, by way of introduction, this use was granted by variance back in 1964, the restaurant use. The house, as you may be aware, is an older house. It was constructed about 1908. In 1964, a variance was granted for the restaurant bar use. It was operated as a restaurant bar for 40 years. I believe initially it may have been the San Francisco or the Stratford Inn. You may remember Gino Marchetti, who was a former football player, owned it as the San Francisco. Then Chef Tell moved in there. And then I believe it was the Stratford Inn. Alberto acquired it in 1993. Acquired it from Chef Tell and in 1993 and operated it as a restaurant through 2004 when he sold the property and then, as I mentioned, retook the property. What we're asking here this evening is just that the prior grant of the variance from 1964 be reinstated, if it has to be reinstated. My argument is it doesn't even have to be reinstated. As we all know, a variance runs with the property, and even though another variance was granted, she never followed through with the permitting process, so her variance expired. We're doing nothing different to the property. The building will remain the same except for some renovation. The parking area and the impervious coverage will remain the same, perhaps some additional plantings. We're just asking to reinstate or to continue with the former restaurant use of the property.
Would you like to swear in your witnesses,
Sure.
please? Your name, please, and if it's unusual, please spell it. Patterson is not. I
Bob
suppose.
Patterson.
Yeah, okay. And, sir, could you please spell your last name? No, not you. Patterson, I think we got.
Yeah, it's Guadragni.
Yeah, I gave cards. So.
And Alberto is your first name, right?
Yes.
Okay. All right.
Alberto Guadagnini.
Yeah.
And you already spelled it. Guadragni.
Could you swear them in, please?
Would you both raise your right hands, please?
Yes.
You both solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so be God.
Yes, I do.
Alberto, why don't I just bring you up initially? You heard my introduction regarding the history of the property. Is that an accurate description of the property?
Yeah, yes.
The building was built in
1909.
1909, and you acquired it in 1993?
I believe, yeah, around that area, yes.
Okay. And from 1964 until 2004, the premises was used as a restaurant. Is that right?
Yes.
Now, I've marked it a zoning application, A1, and this is your name. You've signed the zoning application?
Yes.
That's your signature there.
Yes.
Okay. And A1A, actually, I've marked is that's the deed, the sheriff's deed, that you reacquired the property.
Yes.
You had sold the property to,
Teresa.
it looks like it's conveyed until Teresa Takis in January 24th, 2005. Is that right?
Correct.
And you reacquired the property under the sheriff's deed on January 12th, 2009.
Correct.
And prior to selling the property, it was used continuously as a restaurant from 1964 until 2004?
Yes.
I think John had a question.
Yes, we gave two of
A6 is the one, John, that is the restaurant use.
yeah, but there were two, A8 and A9, where we gave approvals to Takis, Teresa Takis. What happened after these approvals were granted? Was anything done at this property at all? Any operations commenced?
Yeah,
Was it
what
vacant?
they did some inside demolition. They never put on any addition, because remember, one of the
Is an
approvals was
addition.
for an
So
addition.
the addition was never built?
The addition was never built. They never occupied the property. They did some interior demolition, but that was all. And there was the only permits,
What is
again,
the extent of the interior demolition?
Pardon me?
How much interior demolition? What did they do?
Well, they actually did a mess there, and we had to go back and about 3 months ago, and
Well, maybe, Bob, maybe
Well,
the architect, why don't we have the
They
architect?
started to do an interior demolition of finishes, and then the property was abandoned. Alberto took it back. We went in, I guess, about 6 months ago and did a complete interior demolition of a non-structural basis, all finishes, the kitchen, the existing kitchen that was still there, and took it down to the bare studs and exposed the structure inside as it remains right now.
So basically, there's nothing left either of the spa or the original restaurant. It's a shell now.
The bar is still there. I mean, that's the only remnant that still remains, but all the finishes have been removed.
And the kitchen equipment and so forth has been removed?
Yes, that's gone.
Now, Alberto, you operate other restaurants and have operated other restaurants as well?
many, yes.
And your intent here is to reopen this or to
To
even
reopen, most likely with one of my son.
Or,
What other restaurants do you operate? Any in the area here?
In the area, I just sold few, but I'm.
well, what you say, what did you, actually, the old Alberto's Newtown Squire?
Oh, yeah, well, I had La Collina, Newtown Square, Alberton City Line, another one, Trattoria in Westchester. I have one now with my son. It's called Teca, and what else? And Villa Straff.
All right, thank you.
Yeah.
Okay, and Alberto, I'm going to show what's been marked as, I believe, A2 here, which is the existing conditions of the property. Correct? A2?
Yes.
All right. And you're intending to reopen exactly in this type of manner as indicated in A2, is that right?
Yes.
And these were the existing conditions actually when you sold the property, and they continue the same today?
Yes.
Then Bob, maybe we can skip to you for a minute and look at, first, Bob, what's your profession?
Architect.
And are you a registered Pennsylvania architect?
I am.
Can we have a microphone there, please?
And I'm going to show you what's, Bob, oh, there you are. I'm going to show you what's been marked as A3 of some elevations. Can you describe to the board what these elevations represent and what your intent as far as restoring is concerned?
Yes, after Alberto retook ownership of the property, he had hired us to go in, and we did what I call an existing survey. So these drawings do not show the new restaurant, but the structure itself as it is right now.
And then A4?
A4 is a side and rear elevation as it is right now.
Now, you've also taken some photographs of the property that's been indicated as A5, and the photographs actually, on the front page of A5, you're showing where these photographs are taken from, correct?
That's correct.
All right, so the first one, which is A51, it looks like it's looking west.
Yes, it's looking from the property west towards the center across Stratford Avenue.
Okay, and across Stratford Avenue is actually the complex that houses the farmer's market and the strip
Yes.
stores in there.
It's all retail.
Okay, and there's only one entrance here, off of Stratford Avenue, right?
That's correct.
And this, as indicated on A1, this is the sole entrance?
Yes.
And will remain the sole entrance?
Yes.
And now A2, looking west, I guess that's similar
It's
type?
just rotating a little bit north. That's-
Right.
Yes,
Again, looking across Stratford Avenue.
that's correct.
And A3 is,
That's looking north towards the Fuchs office complex.
okay, and matter of fact, maybe it'd be a good time to show, you have an aerial view of the properties here. And you don't have this as an exhibit. I'll just point this out to you. Here's Stratford Avenue, correct? And Lancaster Avenue?
Yes,
And this is a split zoning district, right?
yes.
You split CO, R4 zoning
R4,
district?
that's correct.
And on Lancaster Avenue, in front of the building, is Enterprise Leasing there?
That's correct.
And then the property next to Enterprise
It's
is?
adjacent bank,
Okay, and then next to that is an office building?
office building.
All right, now coming down Stratford Avenue, you have the subject property.
Correct.
First, you have Enterprise Leasing, then the subject property.
Correct.
All right, then across the street, you have,
The strip center, the parking, the shopping center,
okay, and then a little bit further down Stratford Avenue, you have
the Fuchs complex, the office complex.
4 office buildings?
Yes,
Okay. And then behind here, as you'll note, is residential, Farm Road.
off of
and
Farm
Windsor.
Road,
Okay.
yes.
And the intent here is not to add any additional impervious coverage, is that right?
No, we're going to maintain the building as is.
And the same with the impervious coverage?
Yes.
And actually, perhaps you may even reduce if you put some
Well,
planting.
yes, it needs to be redone.
Right, okay.
Nick, does this go to planning at all?
No, it will
Okay.
not, because we're not doing any additions to the property.
Then I'll ask the question. Right now, you have a cyclone fence around that. Is that going to remain?
No, that's a temporary fence. That was a
For
life safety
construction?
issue during construction.
Okay. And so will there be any sort of fence around it at all?
No.
Just plantings?
Not at this point.
You'll
We
redo all
haven't
the
discussed
plantings?
that, but I don't envision a fence there at all.
Okay.
Couple of
Excuse me.
questions, if I may. Is A2 or A5 the plan that we would base, assuming this were approved? Would it looks like they're both the same, but the A5, although smaller, is a little clearer. I guess it looks.
It's A2.
It's A2 is the plan. Secondly, assuming the board were to grant this, would the variances for the spa be terminated and deemed relinquished?
They are already terminated, actually, because more than 6 months.
That would be confirmed.
Yes.
You would agree that that could be confirmed?
Yes.
In an approval if granted?
Yeah, and that's correct. And as I said, they've already been terminated since more than 6 months has expired. They got one extension back in 2005, I
Yeah,
believe.
they would have had to because they then got the second one for the use.
Right.
But basically, the building and its impervious coverage and parking and all of that is the same as it was back in 2004.
Correct.
What-
Yeah,
what-
nothing's been changed.
When you look at the plan, you see Windsor Avenue not opened.
Yes.
Is there any fence along that area?
You know if there's any fence there?
If there is, it's a side yard to one of the residences. I don't know if they have a fence there or not.
Well, I'm looking at the ordinance, Appeal Number 911, public hearing held Thursday, April 30th, 1964. This is the findings, opinion, and order of the Board of Adjustment, which is what this body was called then. Condition number 1, it says a solid 8-foot-high stockade or woven wood fence will be erected along Windsor Avenue to completely screen all parking and traffic on the premises. If parking is extended to the rear of the Farm Road homes, which apparently it has not been as of now, such fencing will be further extended to effectively screen parking from such homes. So it looks to me that there's a requirement for a fence there.
No, but
And if it's not there, and we want this reinstated, they're gonna have to put it
No,
up.
we don't own the property. We don't own the property here. This Windsor Ave right here, this is owned by this residential person here. Our property.
There was never any fence before, anyway.
Our property, hold on. See, this, if you look up the map here, this house, this is their side yard here. This is not owned by
Oh,
the owner.
I don't think they're telling you have to put it up on the border of Windsor Avenue. You have to screen it from the extension of Windsor Avenue. It says to completely screen all parking and traffic on the premises. They were concerned that nobody along the Windsor Avenue not opened could see the traffic or the parking.
This.
If you'll read it, does everybody have a copy of this
Yeah, it says
decision?
a solid 8-foot-high stockade or woven wooden fence will be erected along Windsor Avenue. Okay.
To screen.
The screen. Now did we allow 8-foot fences back in '64? Because I don't believe we do now. I mean,
I'm sure we allowed them if we ordered them.
But,
No,
I mean,
yeah.
The question would be, if you were going to revisit that condition, should it be revisited as a 6-foot fence, which would conform to the zone?
Are
But the screening was
residences
the
still
issue.
along that Windsor Avenue?
There.
It's still
Windsor-
residential?
Perhaps, let me explain. Windsor Avenue was Windsor Avenue at one time extended all the way out to Stratford Avenue. All right? It's basically a paper road from here to here. It's never been opened, it's never been dedicated, or anything of that nature. At that time, back in 1964, it was not a paper road. It was actually a road that could have been dedicated and could have been opened. And so I assume that's
Was it
where-
built, you mean? It was built and in use in '64?
Pardon?
Was it built and
Oh,
in
no,
use?
it was never built.
Then it was always paper.
It was always paper, except for this little portion right here.
But even when this requirement was put on, it was paper.
It was paper, but I don't believe these buildings were here at that time either, these office buildings. You know, the
Is
only
that what's
thing
on
I
the
can-
other side of this? Is that all office buildings?
Yes. On the other side of the paper Windsor Avenue is now all office buildings.
That's
And
all
we
part of
spoke
the
to
Stratford
Mr.
office.
Fuchs. I
Yeah.
mean, he has no objection, and he doesn't care if a fence is there or not, because he wants his people to be able to walk across to get there anyway.
So this does not abut residential at this point?
No.
Well, to this
the
one
only
side, it looks like
residential
it
is
might.
These two homes back here, but as you see, they're on Farm Road.
Right.
See, there's a brief, I think there's like, I don't even know if this is open, Noah. I think this is really just a driveway here. Yeah.
That's my
Right here,
understanding.
this
is-
little portion right here.
I know the folks who live at that corner, and I'm
They
pretty
changed
sure
it.
it's a driveway.
It's a driveway. They don't want it to be a road, I'm sure. And so, as I said, this was, I think, at one point, maybe when Windsor Avenue, this side of Windsor Avenue was built, maybe it was to extend all the way through to Stratford Avenue, but it's been more than 21 years. And it's never been open or I don't know if it was dedicated or not, but it's never been used for over 21 years.
We'll wait till the end for that, please.
Nick, is there any traffic study, updated information you have? Because the new buildings have come, new office buildings have come in that area.
Oh, no, but they've been.
But the restaurant
Yeah,
was
the
there
restaurant's
after
been
that.
there
Yeah.
as long as the office buildings have been
But
there.
it was not in operation for the past 6 years.
Since 2004, right. It's been,
I mean,
you know,
I'm
the
just,
restaurant's been used, continuous for 40 years prior to that.
I understand, but I am worried about the traffic on Stratford Avenue, whether it is going to increase, because now there is no traffic from the restaurant for the past 6 years. Now you are
Well,
opening up.
Right now, you have Stratford, you have Lancaster Avenue, and you have Stratford Avenue here. So the traffic comes from Lancaster Avenue onto Stratford Avenue and exits from Stratford Avenue onto Lancaster Avenue.
Yeah, that's the problem, taking a left out of Stratford
Yeah, oh,
Avenue
yeah,
and
we
Lancaster
can't do
Avenue,
it. Yeah, it's
which is the
tough.
hump of the road. That's very
Yeah.
dangerous.
And normally what you do, my office is right here, and what you do, you never go there to make a left. You come out here, the Eagle Road, and then go out to the light here. But you're still all dealing with commercial properties here. You're not going through residential areas. What you do, if you're here and you want to go west on Lancaster, you're going to come out to Stratford, go to Eagle to the light, and then make a right on Lancaster Avenue.
So, I mean, it's the position that you already have a variance and you just want to
We're
go back to
just-
operate
we're
under the
going back to
variance?
Operating under the variance runs with the land.
Well, the point is,
And-
then so does this condition, Nick, because this is the variance. This is the variance. So
But remember.
if
the
you want to
condition-
change the existing variance, then we need to talk about that, but this is the variance.
Then I would request that this condition be modified because Windsor Avenue doesn't exist.
I was
at
going to
least
say, I
along
mean,
the
how would they
property.
put a fence? They'd have to put the fence through the parking lot of the office
No, along
buildings.
that border. They'd have to put it along the border that faces the Windsor Avenue unopened, is what they have to
But
do.
where is Windsor Avenue?
It's plotted
Where it
on this
would be.
map. The right-of-way is shown there.
Yeah, but look at the aerial. I mean, if you look at the aerial, it looks like it's gonna,
I'm just saying, we don't want to reinstate this ordinance without dealing with this issue, because that is an express condition of the variance that was granted.
Yeah, I think
For
that
our
Noah-
sake, and perhaps for the applicant's sake, we need to deal with this issue.
Part of this property backs onto the back of the bank, yes?
This bank here, yes.
Yes.
I think Noah's absolutely correct. If their position is that the variance is reinstated because the other variances were never acted upon, then that 8-foot fence, which I believe would not comply with the township's zoning requirements now, is part of the condition.
I don't know if we can reinstate the
Well, that's-
current
I have a
variance.
little
I
problem.
kind of think that variance has been abandoned.
I have.
You know, once they gutted the restaurant and took the kitchen and everything out, it's no longer a restaurant. I think.
But
they
let me
need to-
just,
Well, I'm
let
not-
me,
again,
I'm not sure I think it's what the interim owner did that constituted the.
Well, yeah, we don't know how much they did. I mean,
Right.
it's not there now, whoever did it.
Yeah.
Right.
let me, on a non-conforming use, you can abandon a non-conforming use, as we know. In our code, I think it says 6 months. But you cannot abandon a variance, because once you get a variance, basically, you now have the right to do it. It runs with the land, it runs to if you transfer the property and things of that nature. I have one case here that I'll hand up, which is appeal of Barefoot, actually, which is a 1970 case. I shepherdized it, has not been overturned. And basically, it said there that, in this case, it was a special exception. It said when it's granted, it becomes a conforming use in order to the benefit of subsequent owners of land, is not abandoned in absence of time limitation. So, for example, if our ordinance said a variance, if you abandon a variance, and the abandonment lasts for 6 months or a year, you've now abandoned the variance, that would be okay. But our ordinance doesn't say that. Our ordinance always says if you don't act on permits within 6 months, then you have basically the variance is
One
expired.
issue, I mean, I think if this was, Philadelphia has both, for its variances, both a requirement that you commence the variance within a certain period of time, and thereafter, if you abandon it for more than 3 years, you lose the variance. Our section 144 just has the commencement part. I'm not exactly sure that, that the law still, where you have a new variance and you've got the place, that you would still treat the existing variance as being there. Variances generally run forever, but on that theory, they could keep basically accumulating a variance for, as long as they commence any of the variances, it stays forever. They could be running 6 consecutive variances, you know, along the way, accumulated over a period of time for a restaurant, a spa, a medical office building. I don't think the law would support that, notwithstanding that we don't have the provision in the code like Philadelphia has. That might be something, if the board thought appropriate, to have this hearing continued and have a memo of law put on that one point. I mean, I don't think the law is that you can accumulate variances along the way. It's just as long as you commence them in time and then end up with a stack of variances. And I just don't, I'd like to be pointed some authority for that proposition.
So are you saying that the Alona ones are not abandoned?
Pardon me?
Are you saying that the Alona variances are not abandoned?
The original 1964 variance.
Excuse
Now,
me,
how about the
Nick, this
Alona
case,
variances?
this
Yeah.
case is a special exception case, not a variance case.
I know, I
Yeah.
said that, I said
Yeah,
that.
I mean, it's
What's the
a-
same standard, though? What's the difference? So you're getting a special exception or a
Because
variance?
a special
is-
exception is contemplated by the zoning code, and a variance is relief from the
But
zoning
no,
code.
that's not the principle. The principle here is that a variance runs with the land. It doesn't expire. It cannot be abandoned absent a section in the code that says that is to be abandoned after expiration of time. And the Alona case.
You mean abandoned
the-
by non-use, for
Yes,
instance?
yes.
Yeah, but what about from an affirmative act to
Get a new
to
variance.
use it in a different manner, for a different purpose?
But in that case, our code provides that you have to do certain things in order to acquire that variance. And that a variance expires if you don't get the permit within 6 months.
But didn't they do
In the
work?
In the Alona case, all they did, they got a permit to do some structural renovations, got no other permits. They got like, I believe,
And the
got no, and the variance expired,
There's a special exception that expired.
They got,
or whatever it was, whatever relief it was, it
No,
expired.
John's talking about this
Alona
reported
case.
case.
No, the Alona case may have been a
It's
special
a special
exception.
exception, okay?
You know, let me make a point too. This property, as you may be well aware, has a long history of people trying to use it. In this instance, in addition to the notices that I sent out a letter to everyone on Farm Road, most of the people on Windsor Road, and several people on Eagle Road, probably about 40 or 50 letters saying that we're having a meeting on Monday night. If you wish to come to discuss this, we can. I got one phone call from one woman who said she likes the idea, she's concerned about noise, which we said we're going to put the HVAC on the ground, we're going to buffer it, we're going to put the vent facing Lancaster Avenue. No one came to the meeting. There has been no opposition to this at all because everyone wants the restaurant to go back. It's been a vacant lot. As you can see from the pictures, it's basically a run-down vacant lot right now.
Oh, yeah. Well, I agree. I mean, nobody is going to the birds of what your client wants to do. The question is, there's an existing variance that has a requirement of a fence. What are we going to do about that?
But
You want a new variance? You want a new variance?
My feeling, no, our feeling is, I don't know where we're putting the fence up because there's no longer any Windsor Avenue, but, you know, if the board determines that you would not want to modify that condition, we'll put a fence in.
I see this as, it's a new variance. I've not been pointed to any authority that suggests different to me. I think it's a new variance. The hardship would be the fact that the existing structure is there and is amenable for a restaurant. The fact that certainly my wife and I were very fond of the restaurants that were there before they closed down. It worked well. Something, they went a different route, doesn't seem to have worked. But I do think we'd have to grant a new variance to, a new use variance to go back to restaurant route. I don't think the old variance is still alive anymore. And the question would be what conditions should be attached. If you simply reaffirm the resurrect or re-grant the 1964 variance, then the fence comes in. And if the fence is a condition that is viewed as obsolete and perhaps not in conformity with, definitely not in conformity with the 6-foot height limitation in the township, then we should, and the board wants to re-grant the variance, then it should be re-granted without that condition. But I do think a new variance has to be granted here.
Yeah, we don't,
I know they
doesn't matter
disagree.
to us what relief we get, you know, to be honest, you know, whether it's
I think
the
it's a
old variance, which I
and
still
it's a
think
new
is valid,
variance.
but if the
I
board
do not
determines.
think that the law supports, because on that theory, you could get variances for, you know, totally inconsistent uses and end up like a, you know, a hand of a, you know, 7-card stud with all these different cards that you can play.
No,
whenever
but John,
you
in this
want.
case, the use expired, the prior, the most recent variance expired. It's not like it was used for that purpose. But in any
It's an
event, as I
interesting
said, we
procedural-
don't,
I would acknowledge that it's an interesting procedural question. What do you do where you get a variance and nothing happens as opposed to the new variance actually starts? I think that is an interesting point.
Well, if we're willing to grant them a new variance, it's moot.
Yeah.
I think, but the issue with the fence is not moot in one respect, only in that it says that if they extend the parking to the rear of the property, so that it borders the farm road properties, that the fence must be there. I think that condition should remain, that if they ever extend the parking back there, that those properties should be protected by that kind of a screening barrier.
Should it be a
And if they
six-
never do that, they'll never have to do it. That's
Should it be
okay.
an 8-foot fence or a 6-foot fence?
Oh, but that's
In
a
conformity with
technical
current
issue. I don't know
zones?
what the size should be, but
Well, current zoning is 6 feet. So,
Well,
you
the
know,
building needs to conform, I think, with current code as far as ADA.
unless we give a variance for an 8-foot fence and make it a requirement. All I'm saying is I don't know what the requirements for fences were in 1964, but it's 6 feet now, I believe.
Matt, I have a
It
question for you.
was, the code was updated in 1980 according to the book by an ordinance, the fencing.
Okay.
What height before that, I'm not sure, but it was amended in 1980 for 6 foot.
Has anybody recalculated the amount of parking needed for this restaurant, how many square feet you have?
we would,
And
remember, it's based on seats and employees. We have whatever amount of parking spaces, we would not exceed the requirement as far as seats and employees are concerned. We have 72 parking spaces. 74?
Yep.
Okay, and then the parking should be put in according to current code?
Yeah, we
With the
would-
planners and so forth?
Well, then we're going to
Because-
lose parking then.
Yeah.
No, but that's not, but then we're not going to land development though, Kathy. We're not.
Well, that's why I'm bringing it up now. Because I think we need to look at the parking since it's not going to land development.
But it's existing. It's an existing non-conforming.
But it was abandoned.
It's
Use
not a
was been-
nonconformity because it was always, the whole thing was
Yeah.
authorized from variance.
But I'm just asking that it be brought up.
actually, as a
to
result
whatever
of
current
decay,
code
it's
is.
probably no longer impervious paving.
Well,
Right
that's
now, it's
true,
probably no longer
but,
impervious.
you know, I think you need to look at the impervious, the amount of impervious that you have and handle the water retention properly and put in parking according to code today.
One thing I'd like to say is that we did not want to extend the parking towards the residential. We want to respect that. We have a 130 feet plus barrier between the edge of the parking and the backyard of the houses on Farm Road. So by upgrading to the new codes of the parking would force us to extend towards the residential. And I don't think that.
Well, you just said there was very little residential back there, that it
Well,
changed.
but there is there's 2 houses there.
Yeah.
And that's always been the concern. I know with prior discussions I've had with those neighbors, they do not want it extended any further back.
I understand
And that's
that.
that's why I assured them we're not extending it any
Okay,
further back.
I agree with you on that. But I think the parking needs to go in with the dividers like you have in current parking. And
Kathy,
it
I mean,
doesn't,
this could, if we had to comply with land development type parking, you may be you know, with planners, with aisle widths and things of that nature, you're basically neutering the value, totally neutering the value of the building. You're probably going to permit a 40-seat restaurant, which
Yeah, which we don't
It's
want to
not-
do.
yeah.
Yeah, there's a lot, it's a large parking lot, I agree that. But I'm just wondering if this should be calculated before we grant this.
The other piece of it is also, the extent that they have to, comply with that, they'd have to expand impervious, forgetting just, if we get granted variance, the variance is only for what is approved on this plan. That would be the subject of the variance. If they wanted to alter that, they'd have to come back to us. We could even put language in there that says you can't expand the parking in certain directions without, as part of the variance. So I see on the one hand, getting a better parking area, on the other, having an opportunity to restrict the parking to the area that it is.
Mhm.
Those may not
Well, my
be at
point
odds.
is, I think this needs to be addressed.
Oh, I
And
agree.
since
I
we are
couldn't
the
agree
only
more.
group that is looking at this, it's not going to planning, then I think it should be counted and see what you can do with regard to bringing it up to somewhat current code, and I think the impervious needs to be addressed. We make everybody else do it, all the residential
But
properties.
we're not increasing the impervious, that's the
Well,
whole
I'm
point
hoping
here.
that you're gonna cut it back some, if you have sufficient parking, but we
Kathy,
don't know.
I'm just telling you, we're neutering the total value of this building.
Well, I
He's not
don't
gonna
want
be
to
able
force,
open it
no,
as a
I'm not
restaurant.
asking you to do that, and I'm really happy that it's going to be renovated and brought back to a restaurant. But I don't think we'd be doing our job if we didn't at least question this as to the number of parking spots and impervious.
Does that mean it is a new variance application?
I don't know.
I think it is a new variance application. And unless I'm pointed to authority that says that you can accumulate variances along the way, which I'm unaware of, I think it's a new variance application. Now, there may be very good reasons to grant it, given the fact that the property so thoroughly failed for the new use that we granted a variance for, that it's back in the hands of the restaurateur again. But
And I don't have a problem with the use at all. I think, I'm very happy with that. But we were making the other applicant look at parking. We make a strip center look at parking when it changes the front and changes the development. And if it went to land development, would look at parking. But I think we need to at least have the numbers to know what the number of parking is required. Now, we could say, okay, you really don't need to do that.
Well, see, obviously, the number of parking spaces drives how many seats the restaurant is going to have.
Exactly, yeah.
And what we're proposing is basically the same size restaurant has been there for 40 years. And that's what we were
And how many
requesting.
parking spots did you have for that?
Hey, John,
before?
can you help me here for a second?
I'm sorry, 74?
74.
Okay.
On the abandonment, if our ordinance doesn't specifically say that, why would we make the determination that it was in fact abandoned? Like in Philadelphia, it specifically says, as you had said, that if the use has been abandoned for X amount of days or years or months, then it's no longer in use. Ours does not address it. So how can we as a board therefore make the assumption that it's implied within our ordinance?
Well, I think that if you have, the procedural thing is kind of a half-fire here. They got the variance. If they'd done nothing with it and wanted to go operate, just continued operating the restaurant, I'd agree with that. Instead, they went in, trashed the place, basically, or gutted it or partly gutted it, and the thing was left alone. And candidly, if they had opened the spa and been running the spa, I think the law would be quite clear that that variance was the new variance and this old one was gone. Query what happens when you get a variance, and take it at the other extreme. They get a variance for the spa. They wake up the next morning and say, why in heaven's name are we doing that? They do nothing. They just continue
Was it a
operating the
variance or a
restaurant.
special exception?
They were variances.
And it was, the variance was for the use, correct?
It's a use variance. It's a
But-
use
but-
variance. We don't know what it was for
But
parking.
they never commenced that use.
They never commenced that use.
But they made efforts to,
Yeah, but our,
demolish and so forth.
But our ordinance kind of infers that you could have multiple uses, multiple variances on a property, because we don't say that anyone ever goes away.
Oh, no, but remember, the Philadelphia model
Oh,
is
but
simple in
That's
action.
Philadelphia model, but
No, but
that's
no,
specifically in their ordinance, though.
Yeah, but I think there's a distinction between simple non-user. In Philadelphia, if you get a variance for a restaurant, you build it out, operate it for 5 years and then close it down for 5 years. Because of the 3-year discontinuance rule, you lose the variance. That's the Philadelphia model. But that would happen whether you go for a variance or whether you sit on your hands. Here, there's been an affirmative act to go for a variance and some action taken in furtherance of that. Now, one possibility.
Maybe in
if we're gonna
anticipation
look-
of it. I'm not sure it was in furtherance of it. It was certainly in anticipation of the use.
Anticipation, I would say something was done to move it away from a restaurant. Now, again, if the board would like, we could, and also wants to address the parking better, we could ask the applicant to come back and ask the applicant to address this continued validity of the variance issue, which I would research myself, and we could be more precise on that, if the board wanted to do that.
Nick, what's the percentage of impervious allowed in,
Yes, remember it's a split zoning district?
yeah, but let's.
But the
let's
CO
look
is
at
so,
the
so
CO.
minuscule, you know, it's
Yeah, right, yeah.
relatively.
Basically,
Right.
we, in R4, it is.
R5, isn't it?
It's R4.
R4.
Is 40%. Currently, we're at 42.6%.
Okay, and then.
The total site. We comply with, we're at only 20.5% in the CO, where it's allowed 50%.
Okay, so you're good then in
And then we're
impervious.
at 41.1, so we're slightly over in the R4.
It can't, in other words, you basically can't expand any impervious that you
Right.
have.
Okay. And actually, in looking at the parking, it's not a sea of blacktop, and looking where your parking spots are. I mean, it's a sea of blacktop, but it's not like parking spots forever.
Yeah, I mean, there's.
They are broken up. And you could, like in the areas between 6 and 7, parking stall number 6 and 7, there's a corner there, you could possibly put in some green stuff in there to give the feel of the planters.
I'm not certain, yeah.
And perhaps in the corner between 32 and 33.
Right. And on the other
40 and
corner also.
41.
I mean, we have no problem with adding, in the areas.
Yeah.
As you're saying, for example, looks like the edge of 41, certainly we could put in.
Yeah.
if it's
I don't know
not,
what kind of motorcycle you're gonna put in 41.
Yeah.
Smart
You
shot.
might have to reline that one,
Right,
or lose it.
Again, remember, this is a survey of existing conditions.
I understand, but you're counting them. You didn't subtract 41, you kind of left it in there.
Well, I think it could
If
be
they
pushed
moved
down a little.
33,
Yeah.
north a bit, maybe they
Okay.
could, maybe 41 would work. Who knows?
Nick, have you done at least an estimate based on the current parking requirement? How many seats are available?
Yeah, what we figured is 72 parking spaces. So if we're saying 10 employees, that you need 1 space per 2 employees, so you're down to 67. And the code requires 3 times 67, which is,
180, 190.
or 2, whatever, 201.
201.
Yes, and that's why we're saying we would just comply with whatever.
Would
the
require?
park- Yeah, whatever parking we have.
Whatever the parking dictates, that'll be the number of
That's the number of
seats.
seats that you,
Right.
new seats and employees that you want.
Right,
Yeah.
and we
Okay.
would, actually, if you had
Whatever
more,
it takes to make it beautiful. I mean, I have done every place I've done in my life. They're all, top-notch places.
201,
if we had more employees, obviously, then we would have to have less
Less
seats.
seats.
Yeah,
201 seats.
or rent parking somewhere.
That would, we have no problem.
AT&T lot, right?
With
Yeah.
max,
Yeah, there we
that would be the max.
Yeah.
That would be
No,
the total
Rosemont
max.
Business
It may be
Campus.
less than that, obviously, but that would be the maximum.
So why don't we comply with the new regs?
The new parking rates, but you're gonna lose probably, yeah.
A third.
A
You'll
third
lose
of
a
the,
third.
Really?
I would think. you
With
would.
just a
You
few
ready?
planters here and there?
well, no, not with the planters, no, if we're putting planters in that area, we wouldn't.
Yeah.
But if you're talking about aisle
Every 10
widths.
spaces with
Oh,
aisles.
okay.
would
What
be-
is the stall width that you have, or that you plan on? Since it
Um,
doesn't look like it's
Yeah, let
flying.
me see, I have a scale, let me see the scale.
Yeah, yeah, yeah.
One inch equals 20.
Because I know we've gone to narrower
They look like they're
spots.
pretty close.
Yeah.
I mean, I'm just.
I think your code is now 9.5 by 18, is that correct?
We're not, it's 9.5 by 20, and just looking at what they have here, this was a plan prepared by Mominy. And it looks like
Should be 9.5.
those spaces, yeah, those spaces are 9.5.
So you're okay?
Yes.
The width is okay.
See, it's not that bad after all. I just wanted to address it.
Yeah, the width is okay. At least just measuring it out, the width is fine.
If we put some
Again,
green-
but the problem is we would have to, Kathy, if we went to the land development routine, then you have 22-foot aisleways and all that, which would probably take out.
Well, if you're going
It's
to
not
land
so much the
development, I
10
wouldn't have
foot-
even brought it up.
Yeah, it's probably not too bad, the 10, every 10, putting a planting every 10, you probably lose maybe 6 or
Look at
7
it,
spaces.
yeah, that's what I'm
But
asking.
if you're going to put 22-foot aisle widths, then you have an issue, you're gonna lose a lot.
Sir, how many seats are there now?
Well, there's none now.
No, no,
It used to
not
be-
now.
It used to be
No, no.
200. It was 200. It was 200.
Most recent time, in 2005, how many seats were? Yeah,
So
so.
it's about the same.
Yeah, so you will be able to meet with that same space for the parking. But anyway, you have to go through the township supervision of any activity.
No, this is, no, that's what we just processed what Kathy was saying. We do not have to go, the only time to go to land development is if we're putting an addition on the building, or we're not putting an addition on the building, because we're doing it basically the same way.
But any construction, township engineers come and inspect, right?
If we did, they would just inspect electrical and.
That
you
was
know,
building
safety
inspection,
compliance.
not-
Yeah, it's building inspection. It's not,
Engineering.
yeah, it's not engineering inspection.
What about parking lot?
No, it would remain the same. There'd be no inspection involved.
Is that true, Matt?
Well, Cora, they're gonna, to address your question with building permits, they're gonna have to comply with the 2009 UCC codes, okay, that were recently adopted. Parking stall widths, we'd like to see, I don't know what, Nick, do you have what the?
I
what
know
the-
they're at least 9.5 to 10 feet wide.
That's fine, that meets the code, as long as they're 9.5 by 20 is our standard.
Yeah, it looks like they're, to be honest, looks like, no, this one's a little, 41's a little short.
I think it could be rearranged a little more effectively.
And
Although it's not that bad.
Well,
no one's gonna,
Just measure, I mean, it's not bad as far as width.
If I put my truck in.
Charlie, I agree. I'm just saying, that putting a scale on it, it is 9.5 by 20. That's all I'm saying. But you're right, you couldn't, you're blocked
park
by
there,
40, yeah.
no one's gonna wanna hear this. I just looking at the second variance that was granted to this property. Now, you're gonna love
You
this.
read too much now.
This is the second one that was granted to expand the kitchen and everything, get close to the property line that separates it from what is now Enterprise Rent-A-Car. At conclusions of law, number 2, appellant will erect an 8-foot stockade woven wood fence completely to fence the parking area. So the issue is no longer a question of that road. It was, in the second variance, they're required to completely fence the parking area.
At this point in time, though, what
Yeah.
would be the purpose of that?
Oh, I don't know, I'm just saying
Yeah.
this is in the
Yeah,
variance that exists, this is the second variance.
John, would we have the ability, if we assume,
second one.
or if we find that the prior variances are still in effect, do we have the power as a board to modify them?
Yeah, you could modify them. I think that the better thing, though, would be to just simply, if the board wants to approve this, I would grant a new variance.
You grant a new variance.
Yeah, just grant a new variance, and make sure that the other variances are deemed, or acknowledged to be terminated.
Incorporate them by reference, except to
You
the
could do
extent
something
they're
like, we hereby reinstate
inconsistent?
and re-grant the variances, grant, the first 2 variances, delete the fencing requirements if that's what the board wishes to do. And I've heard several statements of conditions. One is the cyclone fence has to be taken down. The spa, the 2004 and 2005 variances for the spa would be acknowledged to be expired. They are, we'd acknowledge that. Parking must comply with, the restaurant must provide parking in compliance with the current parking requirements. In other words, they can't have more seats than employees than they can support with the parking on site. And I think I've also heard that there should be no more increase in impervious surfaces from what's there now.
And I'd like to suggest that there be, I'm not quite sure how to phrase this, but I'd like some green space in the corners there, between 6 and 7, parking spots I'm talking about. 6 and 7, 32 and 33, 40 and 41. Just in the corners, green in the corners.
No problem.
Yeah, I didn't figure as much. And my thought there is rather than have planters on top of the impervious, dig it out somehow so that it's.
Okay, so you would, 40 and 41, 32.
It's the 4 corners, it's the corners.
Yeah.
You look at the corners of the parking.
Yeah.
That are dead.
In the existing interstices.
What's it?
There's
In
only
the,
3
in the
corners.
existing interstices between the spaces.
Right.
There are only 3 corners unless I'm missing something.
Yeah, 3.
That's
2, 3.
6 and 7,
The fourth one is the driveway.
and 32.
3 corners.
40.
Yeah. 6 and 7, 32 and 33, 40 and 41. Just those 3 corners.
Since they're 50% impervious, it shouldn't be too bad.
That will stay, yes.
Yeah, the one in the middle.
Mhm.
No, but
I mean, actually, it's one of the beautiful ones. Japanese maple, yeah.
If the parking is reduced, is that possible? You can have a valet parking arrangement so that
I
if
think
there
he
is
did
an.
do valet. Yeah, I think,
You have.
I think he's had valet in the past.
To the AT&T parking.
So there is a
Yeah,
portion,
to
you know, there
AT&T.
is,
There's nowhere to valet them to off the
No, it
property,
would have to be on site, have to be on site. Yeah, we can't-
unless you made a deal with the office complex
Fuchs's.
for after
Yeah.
hours or something.
Sign at least made.
Yeah, there's plenty of spots
There's
there.
plenty of space.
Well, they're talking about,
Yeah,
they're
we're
talking about
just-
off-site,
Folks, folks.
to gain additional capacity.
We don't want that written.
It's inside joke.
Everybody thinks they know how to run a
Yeah, folks,
restaurant,
okay,
and everybody's got.
point taken.
Okay. Any other questions from the board? No? Anybody in the audience wish to speak to this? How close, come up, come on.
Make this-
My name is Jim Schneller, and I live
Far away.
2,000 to 3,000 feet. I'd ask to speak,
Okay. Jim, obviously, I would have to object to Jim.
Yeah, you're
You know,
standing.
I have no idea what Jim's going to say, but, you know.
But
You know, I have to object to
probably
Stan.
not
He may
good.
say something nice to me this time, I don't know, but,
Yeah.
but I still.
Well, we still question your standing, but go ahead, make your statement.
yeah, thank you. I live, I regularly bicycle, walk, and otherwise traverse the entire zone here as a shopper, as an exerciser, jogging, and I have for 40 years. And if I could just clarify something, and tell me if I'm being redundant real fast, because it's near the end. There is indeed a paper road.
Right.
But I think the fence that was asked to be, or told to be put up for the spa was, meant to screen these backyards from these 2 houses. But it seems to make no sense, because these backyards of 4 homes on the extension of farm, which is just a driveway, never had to, I believe, for the office building. So I thought that was pretty arbitrary. I'm really here as an observer, and I'm here because I recently submitted an idea to the Delaware Valley
Does that have anything to do with this
Regional Planning
particular
Commission.
plan?
Yes. And I proposed to them a few spots where I thought addition of sidewalks or walking trails might really benefit the township. And I simply wanted you to know that it would really benefit the township, and so many people I know are disappointed that someone's put a fence at the end of Windsor across what is not their property. So someone has sought to keep this paper road from ever being used again, and has put a fence from this property.
Jim, I don't think that has anything to do with this particular property, because it seems the area that you're speaking of is not on the property, but adjacent to it.
Yes, it's only adjacent.
Yeah, okay. I don't think that has any bearing in this case, and we can't answer your question or do anything about it.
I understand, except that I thought it was fascinating, and I also think that the zone is the only body in the township that would ever take a look at the ownership or the easement of whatever.
You ought to talk, see that gentleman right there? Tomorrow morning, go see him, he'll help you.
Actually.
And I was saying that, I'm saying that truthfully. I mean,
No.
he's the one that would be able to look into that If there's a fence that should not be there,
Okay,
he's the
let
gentleman.
me-
Right, but I'm making two different points.
Okay, well, let me just read this one thing. In the original 1964 hearing, item number 4, appellant agrees to cooperate with property owners of Windsor Avenue to close it permanently. So that was part of the zoning order 1964 to do that. Evidently, all parties agreed at that point to do it. So somebody back 40-some years ago decided to
Was
do
that for
this.
the first variance?
The
for
first
restaurant?
variance when it was granted, when it, I guess it turned from residential to restaurant.
Yeah, I would have to question, particularly under present circumstances, whether that's an appropriate condition for the use
I wouldn't say
of
it is for this,
for
but
this.
I was just reading
Yeah,
that to answer
it
your
was-
question.
But the bottom line is, streets and things off property are either the township's job to enforce, not the zoning boards. We have no enforcement power. That's something that
Right.
people don't understand.
And the real reason I'm here is solely to let you know what I, as an individual, had proposed to the regional planning, and what I hope to propose to the planning commission is that, and it's a wide right of way. I mean, the old Windsor, you can see it still. If you look hard, you can see a good 25, 30 feet. And I'm simply asking for a paved 5-foot trail. And I wanted you to know that in case it affects your decision.
I don't think it does because it's not on this property.
Yeah, I
It's
don't think-
adjacent to it.
I don't think we
Right.
could. I
Okay.
don't think we could take
But,
that.
yeah, perhaps you should contact your commissioner, I believe it's Bill Spengler, who actually likes to work on sidewalks. And,
He's tickled by all my
I know.
ideas.
But I think maybe the sidewalks as a whole in Radnor Township should be addressed at a different hearing.
Yes, thank you.
Okay, thank you.
If we're at a conclusion, I would request the exhibits be made part of the record,
Okay.
please.
Any further questions from the board? Peter, would you like to take this?
Yeah, I move that we grant a variance under the assumption that the old variance did indeed expire, or at least grant one just to make sure that there is one that's current, with a couple of requirements, that there be no additional impervious coverage taken up, that the...
No, we wanted additional impervious taken up.
Put down.
We don't, I'm sorry.
No additional put down.
No additional impervious coverage.
Yeah, right.
Yeah,
Would it help
okay.
if I read the conditions that I've heard bandied
Okay.
about again, just, and you
Yeah.
can see if I've got them all? The conditions, the changes that I have from the other variances are, we'd eliminate the obligation to cooperate with the closer of Windsor that was in the first variance. We would eliminate the fences in the first two variances totally. We would require that the cyclone fence be taken down. We would include an acknowledgement that the spa variances in 2004 and 2005 have expired and are no further force in effect. We would require that the parking for this restaurant, in terms of seating and employees on site, must comply with the parking requirements set forth in the ordinance as it is today. We would say that there can be no further impervious surfaces. Indeed, the little corners between spaces 6 and 7, 32 and 33, and 40 and 41 would be pulled up and replaced by green. And the planter in the middle of the existing parking lot has to be maintained.
Yes.
Can I just say,
Existing variances for the restaurant were also to be acknowledged as expired, right? This replaces them.
Well, this will be replaced, we would call, I might put in regrants or something like that, or reaffirm, something that takes it over, just so there's, we have our best of both worlds. But I would strip out the stuff that is obsolete and add in the new conditions.
Yeah, I think the key here is that we infer that we're just updating what's currently there with a new one.
Yeah.
I think that keeps it a little cleaner
Okay.
for
And
us,
it will
I
be,
think.
it will be, like 2010 variants rather than 2000.
and John, just,
Say it again, Cora.
It is a new variance of 2010, using the old variance as the baseline.
I think actually what Charlie was saying is we're doing it both ways. It's a new variance, but we're also reaffirming the old, and we're fixing the whole package
Right.
so that we eliminate the points that I said we would eliminate and add the new conditions Plus any other conditions I've missed that need to be added.
Yeah, John, I think also just on the parking, it was that the seating will comply
Yes.
with
The
the
parking.
parking, not that the parking would
Right.
comply with
The
the
seating
new.
complies to parking. If you have 20 parking spaces, then your seating will not exceed whatever the current zoning ordinance is, but I'm using that as a number.
Yeah.
Right? If you have 80, then it would be 80. You can have
Right.
more seats relative to the number of employees and the number of seats
Correct,
currently in the current regulations.
correct.
As
Yeah,
of
but-
today, but if they change the regulations in 2011 to make
Yeah,
it less
sure.
favorable to restaurants, they wouldn't, they
No,
would be
they're
covered
complying
by
with,
there.
in today's book.
Right.
Not
Today's book.
2011 book or 2012's book. It's the year you
Yeah,
got in.
And we're not redoing the parking area
Right.
except for adding
Right.
the
Green
landscaping
space-
that we talked
Green
about.
space where we talked about, the
Right.
3 corners and the planter.
Okay. Good. No further business then? Well, actually, we need to vote.
Yeah.
Forgot about that.
Yeah, I just wanted to observe that as an additional point of hardship, from my perspective at least, is that this property, which is at least nominally residential, is surrounded by land which is, at least in character, entirely and historically commercial. And so, from my perspective, this is an island of residential land in a sea of commercial property.
Right. Charlie?
I concur.
All right.
I agree. I believe that the hardship is the fact that it really is commercial area. It's been a commercial establishment since 1964, which is, a couple of days.
Yeah.
So,
And also, we're maintaining a historic building on there. I agree.
I
Charlie?
concur with that.
Okay.
Yeah.
All right. All right,
Thank you.
passes then, thank you.
Thank you.
No further business, then the meeting is adjourned.